get Andy.
You ready to hand them out?
Yeah, we'll get Andy and Adam to hand them out if we can. All right, I'm on, I guess. And so Ron, if he doesn't like anything I have to say, he says he's going to cut. He didn't say that if Clay finds anything I have to say objectionable that he'll cut me off. So I think I'm good. If y'all would, please don't look at the second page of this handout quite yet. I think we've already got someone that sneaked that. It's all right. That's the second one. Small. Okay. Thank you, guys. Good. Appreciate it. Does Clay have one? Okay. No, thank you, sir. All right, guys. Clay asked me some time ago if I would speak on a Wednesday night. And without hesitation, I told him, absolutely not. He said, well, you don't even know what the topic is yet. I said, well, what is it? He said, you get to talk about death. I said, well, Clay, if you had just led with that, of course, more than happy to do that. That is everyone's favorite topic, right? On a more serious note, guys, we're talking tonight about some things that are practical estate planning tools that will help with the distribution, the disposition, the transfer of assets that you have in an orderly fashion, hopefully to help avoid some issues that can come up with that if you don't have these in place, not just with the disposition. You've got other issues involved there with tax issues potentially and things of that nature. So we're going to go over these. But before we start, I know that Clay really likes statistics. So the second handout that I gave you, I've got some statistics here that are pulled. These are 2026 U.S. death statistics. I can't say that twice in a row, much less 3 times, but the statistics. And it talks about the generational mortality breakdown here. And it does it by generation, and we've talked about that in church, these different generations. And you can look and see the leading cause of death for each generation. Guys, I think it's particularly disturbing that you've got the millennials and Gen Z, that one of the top 3 or 4 causes of death in that age category of 14 to 45 is suicide. Guys, we've got a younger generation that if we don't get them in church, if we don't do the things that we need to do as parents and grandparents, guys, we've got a generation that does not have hope. And if you don't have hope, people perish. And we've got young kids that feel overwhelmed, they feel hopeless in today's society. And so that's a disturbing statistic to see. Breakdown by gender. Wives outlive husbands. It's just the way it is, okay? On average, 7%, or by about 6 years, okay? We look at Alabama's death rate as that compares to the national average, and we are significantly higher. I'm not quite sure what that's attributable to, but we're quite a bit higher than the national average. Median age, Tuscaloosa is actually better than the rest of the state, a little above average, about 75.8 years overall. And so I pulled these statistics from U.S. Census, Alabama Department of Health, Caring.com, I'm not sure if anyone is familiar with that. They provide information about a loved one that is in hospice or dying, or that has recently died, for family and friends to support. And the rest of them I just made up. Okay, y'all can choose which is which. Guys, about 60 to 70% or higher of Americans die every year intestate. That means they die without a will. Okay. The most common reasons for that: procrastination. We get busy every day, right? Real busy. How many of y'all had a busy day today? Most of us, right? And we stay busy. It doesn't seem like there's enough time in the day, every day, to get done what you need to get done. And so that's something that's easy to procrastinate and put off. We always think we've got tomorrow. You know, I think we all are aware of the passing of Will Roberts on the 23rd, 15 years old. Clay, how many funerals have you preached this year? Quite a few. We're halfway through the year. And I think that we all, know somebody who has passed recently, family or friend, and you can't turn on the news without seeing some news about someone getting killed in some violent crime. Double homicides. We've had 2 of those recently. A break-in with a young man was 17 years old, was murdered, targeted murder. We think that we've got time, and we don't know if we do or not. Only God knows if we've got time. So procrastination is one of the biggest reasons that nobody has a will. And then there's some discomfort with mortality. That kind of surprised me. Anybody uncomfortable talking about their mortality or their death? Carson, you good with that? We're going to talk after church, buddy. Talk after church. Nobody wants to talk about it, right? And yet, I think, if I'm not mistaken, Pat, correct me on this if I'm wrong, I think we've only had Enoch and Elijah so far that made it out alive, right? Guys, we're all going. It's just a matter of when, right? And so while this is good to prepare us for what we have here earthly, we need to be eternally minded. We are sojourners here. We are stewards of what God has blessed us with while we're here, but we also have a biblical responsibility to care and provide for our families. And so these are just a few things that will help with that, so that it's easier for them. This isn't so much about me or you, it's about your family and loved ones, because they can get in a situation sometimes really quickly that if you don't have some of these in place, then it's tough to do. Okay. Lack of urgency, that kind of goes back to procrastination a little bit, but unless there's some sort of major life issue that comes up, where now you've been diagnosed with a terminal illness or injury, and you're given a short period of time to live. Now you think, I've got to get my affairs in order. So something like that happens, and now all of a sudden it's urgent that you try to get some of this stuff done. And then you've got uncertainty about beneficiaries. That should have been on page 1, so that you didn't look at page 2 yet. That's my bad. I'm going to blame Theo with her bad eyes. He didn't catch that, and we proofed it. Ron, can you take that off the record? The beneficiaries, sometimes it's tough to decide, who am I going to leave specific things to? And for all of us with kids, that can change sometime day to day, hour by hour, right? Depending on how they act. We're going to write them out of the will. You get grandkids, hey, Tyler, I love you, son. Jeremiah's got it. You better be good to him, all I can say. So sometimes there is uncertainty there. We don't know the right thing to do with that situation, and sometimes we worry that what we do may have an unintended consequence or effect. And so that's another reason that people put off doing this. So, all right. real quickly, guys, I think everyone's looked at the second page already, but, why do wives outlive husbands? Or why do husbands die before the wives do? Short answer is because they want to. They want just a few years in heaven with some peace and quiet, okay, before their wives join them. All right. In reality, it's because guys were idiots. And so you see a couple examples here of what guys do. I thought about Clay with a lawnmower. I thought about Andy with a car. And thought, that's something that I would probably do as well. Our idiocy, making jokes like that, can contribute to a shorter lifespan as well. All right, guys. So those are the stats. We're going to get into the actual presentation at this point. I want everyone, if you will, we do have a lot to go over. We've just got a few minutes to do it. And so if you will hold your questions to the end, I would appreciate that. And also, I want you to know that presentation is free, questions cost. So choose them carefully, okay? Choose them carefully. All right. What we're going to cover tonight, 4 main things. We want to leave here with a little bit better basic understanding of estate planning and the importance that it has. The key documents in a basic estate plan, many of you probably already know this. Designation of beneficiaries and asset distribution. And then how do we implement it? It doesn't do you any good if you know about it, if you never follow through and do it. If you procrastinate, it never gets done. And then sometimes it just can get really difficult or even too late to do. All right, so let's talk about the timing. Anytime's a good time if you don't have a plan in place to start the conversation with your spouse, loved ones, talk about it. Generally, New Year's is something that kind of triggers these types of things that you think about, right? Everybody wants to, lose weight. I've done exceptional with that this year. Maybe not so much. You want to try to get in shape. You want to try to do better with your finances. You want to do some of these things, and you set that out as a New Year's resolution, and then life gets in the way. It doesn't happen. But that's a good time to do it, to go through, kind of take an inventory of where you are in life and what you may need to do with respect to these things. If you've got a major change in your circumstance, obviously that merits then either the implementation of this or a revision of it, a review of it to see if it still meets your needs. So we're talking about death. You got death of a spouse. That changes things, right? Now your plan may not be what you need it to be. You got an addition to your family. Now things may need to change. You've got a child that's attained the age of majority. Maybe things change. You don't need quite as much life insurance in case you as the sole breadwinner or primary breadwinner dies and your spouse then has got to have that money to take care of the children until they're grown. So major circumstances in life, it's a good time to think about. It's a good time to review. What does it do? Overview, basically, in a nutshell. It involves the managing and disposing of assets during life and after death to ensure orderly transfer and fundamentally to provide for access and transfer quickly and sometimes without the necessity of probate. Okay, everybody thinks I've got a will, then my estate doesn't have to be probated. I'm good. That is a goal, of course, to reduce probate, the necessity of it, or the cost of it, or the length of it. We'll get into that a little bit later, but that's certainly a goal, but that doesn't mean that will absolutely accomplish that, okay? Asset protection. We all work hard for what we have. Yes, it's material. Yes, we can't take it with us, but we do want to leave it to our children, okay? Or our spouse, or our loved one. We don't want that just going to the state and the state then deciding what to do with things you've worked for your entire life. Okay? Family provision kind of touches on that as well. You want to make sure that your family's taken care of. I think that is a spiritual obligation that we as men have. to our wives, to our family, that we need to make sure that they're taken care of, especially in light of the fact that they're probably going to outlive us, right? We're not going to be here to provide for them. We need to make sure that we take the steps to do that so that they're not left in a situation that they're wanting or hurting or needing. And we have the ability to do that by just implementing a few of these things that we talked about tonight. Tax and legal efficiency. Again, this is basic estate planning. Guys, we can get into complex estate planning, and you can talk about trust, you talk about all kind of tax, where you get really in the weeds with it. But that is one of the goals, is to try to either reduce or eliminate taxes, whether they're gift taxes if you do it while you're alive, estate taxes afterwards, generational skipping tax, whatever it may be. You want to try to reduce what the government gets. Who believes the government already gets enough of our money? Okay, only one person. All right. You see me after church too. They already get enough, guys. We don't need to make it easy for them to get more of it when you can avoid it with a little bit of pre-planning. And then again with the probate, if you can avoid probate, that is helpful to do. Okay. Let's talk about some common misconceptions about estate planning. I think the biggest misconception is that you have to be wealthy or need to be wealthy in order to have any of these things. And certainly that's not the case. We need to look at what estate planning accomplishes with these basic tools, and we also need to understand what those don't do. There are a lot of things that pass outside of the estate, and so you need to be aware of that. That needs to be a part of any estate plan that you have for that to be an effective, comprehensive, cohesive plan that is actually going to accomplish the goals that you have for it. Okay. Again, misconception number 2, largest one, is if you have a will, it avoids probate altogether. Certainly that's not the case. There are a lot of times, depending on the type of asset that you have or the way that that asset is titled, that you still have to probate or go through probate for that asset to then be transferred. If you do have a will and that will provides for the transfer of that asset, then certainly that gives guidance to the probate court so that that helps them understand what your last will as to that was. And so you hope that they will honor that will and that they will allow for the disposition of that asset as you had intended. Doesn't always happen, but sometimes you still have to probate regardless. Another one is that you absolutely get to choose who is going to be the guardian of any minor children that you have. Okay, it's not just children. There's a lot of people that have they're taking care of grandkids. They're several generations. You've got special needs individuals that may never be able to be fully independent and are always going to need the care of somebody, some caregiver that has the legal authority to provide that care for them. So it's not just minor children, but it's anybody that is a minor. You don't have the legal or contractual capacity to act on your own or do for yourself. So having said that, let's address this first misconception as far as being wealthy. Are any of you trust fund babies? All right, guys, I'm done here. I'm just kidding. I think that all of us are as believers, right? Romans 8:17. We've talked about that recently in church. We're all joint heirs with Christ, right? We've got the ultimate trust fund. Jesus said, "I go and prepare a place for you." You can't get better than that. That's an irrevocable trust. We're not going to talk about trust much, but you've got two kinds, revocable and irrevocable. That's irrevocable, guys. The grantor cannot revoke the provisions that he had provided for that. So I think that we all are very wealthy in that regards, even if we may not be here on earth. Okay? All right. Let's talk about why everybody needs an estate plan, especially if you have minor children. Okay? The first is so that you can determine the asset distribution we talked about before. You want to be able to protect your loved ones and make sure that they don't do without. I don't know how many people in this room have had that situation. Well, they have a loved one that's suddenly incapacitated or suddenly passes, and now all of a sudden, you're lost. You don't know where anything is. You don't have access to anything. You don't know what they had. That is not a very comfortable feeling, as you have to try to investigate that and try to explore, digest what they've got, where it is, have issues there. So this allows you to provide for your loved ones ahead of time. It prevents family disputes. How many of you guys ever argue with a sibling about something? One or two. I probably did once, maybe twice, a few more times. It happens, right? Parents are gone, kids are there. What do you see happens so often? Parents aren't even cold in the ground yet, and they're fighting over everything that they can fight about. And guess who normally benefits from that? Somebody like me that's got JD at the end of their name, because then they all lawyer up, and the lawyers wound up getting everything that's there of any value because they fight until nothing's gone, they spend it all. A little bit of this prevents that, okay? It happens. It happens a lot. You would think that that's when family would come together and do the right thing. That's not what happens most of the time, okay? All right. Avoid state law control. We talked about that before. Alabama's got a tiered system for intestate distribution that just depends on your marital status, if you have children, if the children are the children of both of the parents, if the children are of another parent, if you die and you don't have any children and your parents still, it's just got a tiered system for who gets what with that if you die and you have a spouse. So the bottom line is you don't have any control over that. The state does. And sometimes you need to get the assets quickly. You need to have, you just lost somebody, and now you're in a world of uncertainty because you don't know what the legal status of any of this is going to be. Are you going to be able to keep the house? I can't get into the account. I can't pay my bills. I can't do some of these basic things that I need to just to live and survive, and at the same time I'm dealing with grief. So some pre-planning will take care of that, and especially if you've got minor kids. I know that young kids, you don't think about it. Young married couples, got small kids. I don't know anybody in the room that is in that category, but if you do, or if you've got kids that have kids, you've got grandkids, they need this, okay? Because something happens to you. You and your wife both die in an accident tonight on the way home, simultaneous death. Who's going to take care of them? Okay? You don't want them to be a ward of the state. You hope someone's going to step in that's going to be not just a good caregiver and provider for them and loving to them, but someone that is also going to provide them with a godly home. So you've got the ability to do that to a certain extent. A court will make the ultimate decision, but if you have that set out in your will, the courts generally listen to that. We'll get to it a little bit further on. Don't just spring that on somebody and all of a sudden, oh, I'm supposed to be the guardian of these 12 kids. That can be a shock to them. So you may want to have a conversation with somebody about that ahead of time. Say, hey guys, if something happens to me, Adam and Aaron, I want you to raise my kids. Y'all don't want to. They eat a lot. Probably don't want to do that. But you need to have that conversation and go. That can kind of, you've got some other issues there with who you choose as well. You want to choose somebody that also has the ability to provide that care. And sometimes we do what we have to do, so we make it work in those situations. But if you've got somebody that is more able to care for somebody because they're in better health, they're younger, they're closer, their finances are better, they've got a better ability to do that, then that's probably who you need to talk to as far as first choice. Sometimes when you spring things on people at the last minute, you kind of get an adverse response to that. So when I text Clay at 5 tonight and said, "Is tonight my night to present?" He responded. He responded quickly. I won't share his response, but part of it was, "I hope you're joking." I said, "Clay, I never joke. Y'all know about me. I'd never joke about anything." All right. Let's get into the actual meat of the presentation here with the three primary things that you've got for a basic estate plan. You've got a power of attorney, an advance directive for health care that everybody refers to as a living will, and a last will and testament, okay? So we're going to go over each of those. We're going to talk about what they're intended to do, what they may not do. And so let's talk about power of attorney first. Does anybody in here have a power of attorney that you have created in which someone else is going to be your agent if something happens to you and you can't act for yourself? Okay. How many of you are agents or contingent agents under someone else's power of attorney? Yes, someone's named you as an agent in their power of attorney. Okay. That's good. That is rare. Typically, we name people to be our agent or a contingent agent. They have no clue until something happens, and now all of a sudden they're expected to step up. So again, it's a conversation you need to have with these your proposed agent or contingent agent to make sure that that's a role that they're comfortable with taking on. There's two primary types of power of attorney. You've got a contingent power of attorney, which is what most people want to have if they are in pretty good health. They think that they're able to take care of themselves for the foreseeable future, but they want this in place in case something happens. Elton does great. 89 years old, does great. Had a stroke, still does great. Didn't know he was going to have a stroke before he had a stroke, I'm sure. We don't know we're going to get into an accident or have this issue that we become incapacitated until it occurs. At that point, it's too late. I no longer have legal capacity now to sign or execute a legal document that empowers anybody to do anything on my behalf. Set this up ahead of time. It's contingent. I get in an accident. I can't handle my affairs right now. Jenny's going to handle them. Y'all, she does anyways. She's going to handle those until I'm able to do it again, and then that contingency is no longer in effect, okay? So that's kind of like a swinging door. It goes both ways. Once you're able to resume, you resume. You don't cede that power to somebody forever and ever, and now you can't take it back. The other is a regular power of attorney. That means as soon as it's executed, it's in effect. I give you a power of attorney over my affairs. As soon as I sign it, you can do whatever you want. Don't take my dog, please. Don't take my dog. But you can do anything you want to do. And it's in effect right then, and then you can't take it back unless you revoke it or rescind it. And sometimes now you got to go and fight about that, right? Sometimes people get control. They don't want to give it up, especially if there's money involved. Now they got control of the purse strings. So be careful about the type of power of attorney that you do. Most power of attorneys are durable, okay? Anybody know what that means? Okay, Charles knows what that means. Charles, we've got 20 minutes left and about 10 pages. You want to come on up? Just kidding. All right. Y'all, it doesn't mean what kind of paper is it printed on as far as durability. Durability means that that agency that you create is only in effect as long as you, the principal, are alive. I can't grant someone the power to act in my state and behalf if I'm not here. That's good up until death. Okay, and I know a lot of things now, we've got almost instant access to information and things. It's not like it used to be. So I'm going to use an example that most of us will get. I'm your agent, Larry. I'm writing checks every month. First one I write's to me. Okay, but I'm writing checks every month. You die. That check's signed out to the power company, cell phone provider, whoever it may be. They haven't cleared yet. The durability means that until I'm aware of your death or the bank is aware of your death, that action was still good. Okay, because otherwise you're going to have a big just car wreck there with those type of transactions. Okay, so that's what durability means when you see that, a durable power of attorney. Selecting an agent. Y'all need to make sure that your power of attorney, which primarily handles anything that you need to do legally, financially, you also need to make sure that it's got a HIPAA authorization so that people are able to handle your health needs. That's the biggest reason people need a power of attorney or a contingent one goes into effect, is the fact you can't take care of things usually due to a health issue. You want someone to be able to do that. Guys, that is it's HIPAA. People think it may be with HIPPA like a HIPPO, but a HIPAA, no, it's HIPAA. It's the Health Insurance Portability and Accountability Act. Anybody that works in the health field knows about it. Guys, y'all know the fines if you release confidential patient information. It's serious. In Alabama, civil or criminal, sometimes both. If you don't know about it and you disclose that information, the fine can be from as little as $150 up to about $70,000. If it's willful and malicious and you're using that for pecuniary gain and you're taking people's information, you're selling it so that everybody knows, I just had a health checkup, I'm great. We're going to grab Marshall and we're going to harvest all of his organs. You know, you can't disclose it. If it's willful and malicious, it carries up to a $250,000 fine per occurrence, up to 10 years in prison. So it's serious. If you don't have authorization to be able to access that information for a loved one that now you're supposed to be taking care of legally as their agent, it's tough. You know, you may not even be able to make or change a doctor's appointment, because if the doctor does that or their staff does that, that's a tacit admission that that person is a patient, that they're treating that patient, and depending on the kind of doctor, that may allow you to infer what kind of treatment that person may be receiving. So it's tough. You got to have this in effect. Okay. Legitimacy. Let's talk about that. Guys, we live in the age of Google, AI. Everybody can go in here and you can get anything that you want to, right? A power of attorney is easy to just print out and look legit. Okay? If you pre-plan this, now you've got some credibility with it, right? Before Larry gets to the point that he can't anymore, and I'm his agent, I'll say, Larry, come on. I mean, you're going to your insurance agent, we're going to your bank, we're going to your accountant, we're going to go see your lawyer, it better be a good one, but we're going to hand him that power of attorney and say, hey, this is legit. I'm here. I'm the principal. I'm letting you know this is legit. Okay? Another way that you can help legitimize it is to record it. It doesn't have to be recorded, but you can record it. The recordation helps lend credibility to it. Now, y'all have worked in the court system, know the clerk of court pretty much has to take anything you give them to record. So that in itself doesn't self-prove it, but it helps lend legitimacy to it. Okay? So just be aware of that. Power of attorneys especially are easy to kind of fabricate or fake. Let's talk about a living will, advanced directive for healthcare. Guys, this is something that Alabama kind of got tired of addressing, and so they actually drafted a form, so there's no pride of authorship or anything else in a living will or advanced directive for healthcare that you get. They wanted them to be uniform so that everyone in the health profession, especially in the hospitals, would be able to read it in the same format, same uniformity, and understand this is what this person wants as far as this living will is concerned. As that doesn't cover every health issue that you've got. It only covers 2 in Alabama. If you are diagnosed with a terminal illness or injury, okay, or you are permanently unconscious. In either of those 2 events, you get to choose ahead of time, do I want to be kept alive artificially or not? And if I don't, do I want to have nutrition and hydration? And if I choose I don't want nutrition or I don't want hydration, speaking of which, I want some hydration right now. Y'all give me just a minute. You may want to cut the mic. You don't want either one, but do you want that only if not having that is going to cause you undue discomfort? Okay? If I'm unconscious, Andy, you can jump up and down on my chest. I don't care. I'm not going to feel it. I'll come to, I might be mad at you too, a little bit. You don't know, okay? If I've got diagnosed with terminal cancer and I've got 6 weeks to live, hey, I probably want the cancer to get me before I starve to death or die of thirst. So maybe I want that to be kept alive so I'm not in pain while I'm dying. So you think about that. You get the choices to do that. Same thing with being unconscious. I don't know that I'm going to feel hunger or thirst if I'm unconscious. But at the same token, I know if I go long enough without food, I'll get angry, don't I, baby? But if I go long enough without it and I come out of that coma, I need it to come out of the coma. So that's just the choice y'all got to make. Everybody can make that decision. You can change those. Just like with a power of attorney, guys, this a copy is as effective as an original. You want to have one of those probably in your glove box in case you get in an accident. You probably want your spouse to have one. You want your primary doctor to have one. You want the people that need that information when something happens to have that so they know, okay? And this living will does something that to me is just defeats the entire purpose. It allows you to appoint a proxy just like an agent under a power of attorney, someone that can act on your behalf. It's a healthcare proxy. Semantics, subtle difference in what they actually mean, but that proxy or contingent proxy, and they can be the same as the agents under your power of attorney or in your will, and be the same people. They can override your decisions if you let them know that that's what you want them to do. That defeats the whole thing for me. To me, this estate planning tool takes the burden off a loved one to have to make that decision. We talked about kids fighting. Mom's in the hospital, all the kids come around, don't know how long she's going to be there, how she's going to make it. They're fighting over this now because no one has a living will in place. So they're fighting over whether or not to keep her alive artificially, pull the plug, whatever it may be. And even with it, you may have the 2, depending on what powers you give them, that are going to be fighting with each other on what they need to do with it. So keep that in mind when you're making your choices under that living will. We're going to talk about last will and testament real quick. Probably not going to get through all the materials tonight. That's exactly what this means. That's my last will. It's what I will to be done. This is my testament, my promise. This is what I'm giving to people, devising to them at my death, and this is what I won't follow by the court. Alabama law does not recognize a handwritten or holographic will, so this is something that has to be typed. Again, you can go to Google and you can get a will. Have a great will, written quick. Don't know if that's going to comply with state law, if it meets your needs, if it's actually going to accomplish your goals, but it's certainly something that you can do. Again, that provides then for just an orderly distribution of your assets, hopefully in a manner that avoids probate if you can, and hopefully that minimizes or eliminates tax consequences to that transfer of property. Most of us in here, and the biggest asset we probably have is our home, our real property, so that's usually the one that is addressed most frequently with this. Make sure that that transfer goes smoothly for a spouse or for kids. All right, and again, we talked about the guardianship for minors. You can put that in your will, who you would like to be the guardian. That's not something that is absolute. The courts get to decide. So again, it needs to be somebody that you talk to that you're comfortable with. Maybe preferably that your kids not are comfortable with, right? So, all right, and then again, it helps with the probate process, even if it doesn't completely avoid probate. It may help the probate court and give them some guidance on what you wanted done. Pat makes a will today. She's going to leave everything to me. I upset her tomorrow. She decides she's going to leave everything to Nancy. The new will, that absolutely supersedes the previous will, okay? So you don't have to worry about that. The new will is what's going to be in effect. Anybody see any issue with that? Yeah, it revokes a prior codicil or will as soon as you execute a new one. All right? Problems with that. We see those come up quite often. You've got someone older. The will that they had 20 years ago left everything to all the kids evenly. Now something's happened. Things have changed. Circumstances have changed. One of the kids passed. One of the kids won the lottery, multimillionaire. One of the kids doesn't have anything to do with the parents anymore. One of the kids has 14 kids and needs all the assistance they can get after you go. Things change. You've got that one kid that still has things to do with a parent that comes around and provides for their care and is there for them and takes care of them and handles everything for them. It says, you know what, Larry, I'm your favorite son. You really need to leave everything to me. I've been the one dealing, I've been here for you. And you do that late in life, or when you have potential capacity issues. You got, someone mentioned some Alzheimer's this evening, may have Alzheimer's. You've got some capacity issues then, and now all of a sudden that new will is suspect. It's subject to contest. That's something you really need to be careful of. Does this grantor, do they have the mental capacity? Are they aware of their estate sufficiently that they understand what they're doing with the provisions of the will? Okay. We're talking about the designation. We talked about it earlier with agents, proxies, executors, beneficiaries, contingents. We're going to talk about that really quickly. I know we're running short on time. The big thing here, guys, choose wisely, okay? You don't want to choose somebody that is not going to act in a fiduciary capacity and in your best interest under power of attorney. You don't want someone that's going to be the executor or executrix of your will that is going to do everything they can to run up the cost of the administration of that estate to benefit themselves. You choose a guardian for your kids. Again, make sure it's somebody that you trust, your kids know, someone that you feel comfortable entrusting those kids to. So just choose wisely. We talked about dual roles earlier. You can have the same person and same contingent under all three of these. We mentioned guardianship several times for minor kids. Guys, I can't emphasize that enough. If you've got young kids, you really need to do something with this. It provides clarity for the court in that situation. Let's talk about what this doesn't do, okay? Essentially, your estate is comprised of all the real and personal property that you have an interest in at the time that it is created or at the time that it is distributed. So, you know, my estate, I'm very wealthy with 4 dogs. The dogs are just priceless, guys. Those are, I mean, love my wife's priceless. But you've got some things that a will won't do, okay? A lot of things pass outside of an estate. It doesn't matter what your will says. I'm gonna leave everything to Carson, right? But I've got $1 million trust fund, and Aaron's beneficiary of it. You gotta be nice to your mom. That passes outside of my will. whoever the beneficiary designation is on bank accounts, life insurance, trusts, things of that nature, real property is controlled by deed in Alabama. You can say, I'm going to leave all my real property to my kids, but if you've already deeded that to somebody else, or that deed conflicts with the provision of that will, the deed controls in Alabama. Okay? So you think about things that pass outside of probate or outside of your will, and make sure that those items, those assets are properly accounted for with beneficiaries for that. Payable on death. It's a real easy thing to do. You can add someone to your financial accounts. It's payable on death. When you go, that's who gets the money. Okay? They don't have access to your account. They can't perform any transactions on the account. But when you pass, then they get the money. And they're not having to wait to get the money. Okay? They get it right away. You can be you can have access to an account without having ownership of the account. Okay, so we had a situation that came up recently. The grandmother wanted the grandchildren share alike in an account. They were minors at the time, named her son as a non-tax owner of the account. Well, that just means any earnings on the account not tied to his social, they don't get taxed. He doesn't get taxed on those. But he owns the account. As soon as she goes, it doesn't matter what she wanted for those grandkids. He's the owner. If he doesn't honor her wishes legally, they're out. So be careful with that. Something that we see a lot, it happens a lot. You're divorced, you have a life insurance policy at work. Maybe you forgot about it because it comes out of your check. You got one at the credit union just because you have an account there. Or maybe you actually got one you didn't know about. Your ex at the time went out and took $1 million policy out on you, just in case. You don't change that beneficiary, guess who gets the money? Guess who's really upset with you? Your current spouse. Guess who all of a sudden loves you again when that check comes? Your ex, okay? So things that you need to think about. Don't ever get divorced, okay? You don't have to worry about that. All right. Guys, something that we've got now that we didn't used to have that is now becoming a real big thing, digital assets. How many of you have got digital assets? You've got cryptocurrency. You've got anything that's digital out there, again, that you're in your estate, you can claim it comprises your estate because you've got a present interest in it or a future interest in it. You don't think about. How many here have social media accounts? How many of those are actually generating income because your posts are so fascinating, you've got 1 million followers, and you TikTok, right? You got all kind of money you don't tell anybody about, right, Carlos? Hey, guys, what happens to those accounts? You've got, your age and younger, your whole life is on those accounts. Who's going to control the content, the photos? If it is earning income, who gets that? How do you stop it? You've got to address the digital assets now in your estate plan, because if you don't, those are going to be outside the will. Now you're going to have to go to court and get a court order that authorizes you to have access to these accounts. Okay? Business succession. Small business owners, it's a big thing. Y'all, something happens to me, I've told everybody, leave the door open. Let everybody come in. They can get whatever they want. I'm gone. I'm not here anymore. It doesn't matter. It may matter to my clients, but I'm out. But you need to think about that if you've got a small business. Do you have a succession plan in place? Because if that business is what's supporting your household and something happens to you, what's your spouse going to do? If it's a partnership, if you've got other owners in the business, whether it's other members of an LLC, an S Corp, whatever it may be, who's going to control that business? Who's going to control that income? You could have accounts receivables that are vested, that come to the business. How you make sure that your proportionate share of that goes to your spouse, your kids, or where it wants to go. You got to think about stuff like that and plan for it, because if you fail to plan, then you plan to fail. Okay? Ron's going to cut me off here in just a minute because I'm cutting into his time. Real property, guys, that's probably the biggest single asset that we have that we worry about as far as from a distribution standpoint, whether that's your home, rental property, farmland, whatever it may be, you want to make sure that that property goes to whoever you want it to go to with the least amount of time, the least amount of expense, the least amount of tax. Okay? Deeds in Alabama, we talked about earlier, that controls ownership of a piece of property in Alabama. Let's talk about a situation real quick where maybe your will isn't going to be sufficient. Say you've got property in Alabama, I've got a condo at the beach, I've got hunting property in Mississippi, you've got whatever there in multiple states or multiple jurisdictions that you're going to have to deal with through some sort of probate in those jurisdictions if real property is involved, unless that is already dealt with pursuant to their state law according to the deed. Most deeds that you see between spouses are joint with right of survivorship. That means that as you each have a 1/2 undivided interest in your property. Something happens to you, your half interest automatically goes there, and she doesn't have to do anything. She doesn't have to go see a lawyer. She doesn't have to go probate. She doesn't have to go create a new deed. She doesn't have to do anything. It's hers by operation of law. Instantaneous. It happens. A lot of people use that as an estate planning tool, and that can be good unless it's not with your spouse. Special rules apply with spouses. That constitutes a transfer of an ownership interest. Technically, it doesn't account for spouses, but if it's to somebody else, and now that's a tenant in common, they've got some sort of a partial interest in the property. We see it a lot with heir property, where you've got multiple heirs that own this property. There's tax considerations there. So, right now, if something happened to me, say me and Jenny both, my son gets the house. Just say on a good day, the home appraises for $50,000. Okay? The day after we pass, he's like, I don't want that house. I never liked that house. I don't need the house. I want the money. I'm going to take Jeremiah. We're going to go on a great trip to Disney. I'm selling it. He sells it for $50,001. Capital gains tax, which is up 35%, there's not any, because you get a step-up basis as of the date of death, or for investments or other things, you can choose an alternative 6 months after date of death. But you get that step-up basis, which is huge. Guys, you hear politicians talk about, doing away with that. That's a huge ability for us to be able to transfer wealth generationally without it being eaten up by taxes, or without the property having to be sold just to pay for the taxes. So that's something you need to think about. If that transfer occurs before you die, now all of a sudden you don't have the same step-up basis, because now that interest that got transferred is a partial interest. So your basis changes in that property. And so when that other party dies and now you get it all, you do have potential capital gains issues there. So you need to think about that. Everybody, kind of defaults to joint right survivorship, and that's good with spouses, may not be quite so good with other properties. So just kind of keep that in mind. Okay. Steps to implement real quick. We're going to be real quick. I'm really eating in Ron's time. He's going to make me join the choir after this. All right. Again, failing to act. You don't make a provision, or the provisions are inadequate for a minor. You don't plan for incapacity. We never know when something may happen. We fail to update as circumstances change, and they do, and then people don't think about it. Guys, an estate plan is a living type of thing with us. As circumstances change, you need to review it and make sure that it still meets your needs. We want to look at whether or not we've got good beneficiaries designated. Change those on the things that go outside the will. If it's inside your will, let's make sure that those are still the people that you want to have handle that for you. You list somebody as an agent, or you list somebody as a proxy, and 10 years later, now their health is to the point they can't take care of themselves. They can't act for you either. So as circumstances change, make sure that you update that. Notification, that's huge, guys. If something happens, how many of you guys have gun safes? Does your wife know how to get into the safe? How many of you have a safe deposit box? Does your wife know where it is and have a key to it and have access to it? How many of you got just a regular safe at your house? It's got nothing in it but paperwork. All right, just saying, nothing in it. That your spouse needs the combination to. What about life insurance policies? Do they know? Who's the agent? How do you get in touch with them? That's something that everyone needs to have that discussion and make sure that your spouse or whoever is supposed to be inheriting this or taking under this is aware of. That doesn't mean share your will with whoever may take. That's a very private document. You want to keep that safe. Only an original can be probated in Alabama, absent some fairly small exceptions. But the others, the living will, you want your doctors to have and your agents for that and for a power of attorney so that they know. Yeah. Run, we got a clock running. Run the clock, please. I'll bill by the hour. Go ahead. And, most insurance policies will allow you to have multiple beneficiaries, and you can do that by percentage as far as who you want to have, what percentage. If you want to have it equal, then equal. You can do that. The other thing that you can do is you can create a trust in your will. It's a pour over trust. You can have those proceeds go into the will, and now the provisions of the will within control. So there's different ways that you can handle that. The easiest way is with beneficiaries. It's the easiest way to do. The biggest thing that happens with trusts, people set up a trust and they think we're good. The trust never gets funded. You've got an empty vehicle here. It doesn't have anything in it. When you crack that nut open, there's nothing there. So, just having a trust in and of itself doesn't accomplish anything if it's not properly funded and administered. But naming those beneficiaries is the easiest way to do that. Okay. Other questions? Okay. All right. Thank you all. Appreciate that. Hope that this was beneficial for everybody.
And guys, one thing, obviously, once we get opened up for a whole lot of questions, because every one of us in here is going to be different. Okay? Nancy's situation is going to be different. Our situation is going to be different. Peggy and Larry's situation, we're all going to be different. Crystal's got kids, smaller kids. Aaron and Adam, they've got older kids. Okay, so everything is going to be different. One of the things that you can do is, and there's a page in here about who to contact, not necessarily who to contact, but the different type of folks to contact. And I would behoove you, don't wait. You don't.
Yep.
Have things set, and then the other thing is, and you hit on this, it wasn't really part of what he was doing, but he hit on this, having stuff put together to where whoever can get to it, all the information from all of these different things, but they've got that information, they can get to it. And the way that I've got ours set up is, hey, kids, here's what you do. Okay? And my dad had no truth to me about what I was supposed to do for the guy. We talked about finances last week. It's important to be stewards of what God does. Okay, so I'm sure probably we've got more questions. We've got one. I want to say real quick too. Look at page 21 on your handout. There's a disclaimer, guys. This is for instruction on educational purposes only. I'm not giving legal advice.